Uh, Good day, Advocate Rugunanan.
Good afternoon, Chief Justice and members of this commission.
Upon completion, what did you do? How did you begin to practice the law? Where did you go to, in other words?
Chief Justice, I studied in Grahamstown at the local university, as it were, and upon completion of my degree...
If you could put the mic closer to you so that everybody can hear you, and drop it a bit. Yes, thank you.
Okay, I hope that's sufficiently audible. Yes, upon completion of my university degree, I found what was then termed articles of clerkship back in 1993, and my legal career started with a firm called B. Sandhi & Co., as reflected in my curriculum vitae. I've been in the legal profession ever since then, Chief Justice, and you would have noted from my papers that there is nothing else that I can do or have done.
Yes.
And since 1993, my career has progressed through various stages upon completion then of what was known as articles of clerkship. I practiced as a professional legal assistant with also a local firm in Grahamstown and in Dulab & Co. Whereafter, at some point during the course of my career, I was absorbed in the Department of Justice, where I was employed as an estates examiner. Having served that particular stint in the Department of Justice, I then advanced my career to practice at the bar in Grahamstown as an advocate. And since 2001, Chief Justice, I've been involved in the practice of an advocate since then to date.
Yes. And tell us why you believe you're ready for a judicial appointment.
Chief Justice, I think it's a reflection of the natural progression of my legal career. And it's the decision I have made to apply for the particular post being advertised culminated as a result of various life experiences and circumstances by which I was confronted. That said, I've held 3 acting stints, 2 of which are reflected in my papers. The latest one, unfortunately, isn't, because at the time I submitted my application to this commission, I was not yet appointed. The latest stint that I have finished was the stint for the 28th of August until the 22nd of September this year. So the nub of it all, Chief Justice, is that I believe I've acquired experience in the judiciary, as it were. I also brought into my acting stints the accumulated experience of my lifetime, as it were, in the practice of law. And to that extent, Chief Justice, I believe that I do have the capability, the competence, and the disposition, and above all, the independence of mind and the temperament to assume judicial office.
What is the longest you have kept the judgment reserved for?
Yes, Chief Justice, the longest period was unfortunately 9 months. That is a judgment which I have included amongst the set of papers submitted in my application. That is the matter of, I will refrain from mentioning the names of the parties, H versus L. It was a very complex matter, Chief Justice. And the fact that the judgment was reserved for such a long period of time assuredly was not as a result of any indolence or incompetence on my part, but also as a result of many other circumstances by which I was confronted by during the course of my return to practice, having completed my acting stint. You will observe, Chief Justice and Commissioners, that that judgment has been commented on by the professional body of which I am a member, namely the Eastern Cape Society of Advocates. They fairly objectively commented that the judgment was not a simple matter. It was indeed complex, Chief Justice. It certainly involved a dispute in the construction and demolition industry. And the matter, if I may just venture to state, the manner in which the papers were drafted on the basis of expert reports, which were not crafted in a way that could be comprehended very easily by a lay person. So, Chief Justice, I, sitting as a single judge, having adjudicated the matter, was saddled with the ultimate responsibility of having to sift all the information. And I would venture to say, Chief Justice, that that particular matter comprised 2 applications that were consolidated. So the volume of the paperwork was close on to 700 pages. I had to sift through all the material in a manner such that upon writing the judgment, the summary of facts and the reasoning would have been logical and lucid.
I gather from your answer that it was an application, not a trial.
It was indeed, so yes.
Now, and I assume you had the benefit of written submissions.
Indeed, I did, Chief Justice. Senior counsel appeared before me and made written submissions in their very detailed heads of argument.
Now, would you say senior counsel were helpful in helping you to distill issues that were central to the determination of the matter?
I would say yes, Chief Justice, but the ultimate responsibility for ensuring that justice was done was mine.
Always.
I had to take, well, I won't say deliberately take my time. The responsibility for ensuring that the arguments were properly, marshaled, comprehended, and reasoned was ultimately mine. And in addition to the submissions made in the heads of argument by senior counsel, I also had to embark on research of my own.
What, in your view, is the acceptable period to keep judgment reserved for in a very complex matter?
Chief Justice, look, one is guided by the norms and standards, which sets a period of 3 months. This was considerably more than 3 months. I accept the responsibility, therefore, but I've indicated the reasons why the judgment was delayed.
No. Nonsense standards aside, just by your own standard, what is an acceptable period for which to keep a judgment reserved in a very complex matter?
By my own standards, Chief Justice, I would gauge it to be a reasonable period. That's obviously circumstantial. I wouldn't venture to want to prescribe any specific period. All I can say that it would be a reasonable period.
What? No. Please help me.
Yes.
I'm seeking to understand. You made reference to the complexity of the matter and other issues which I assume you're not comfortable to mention. But all things considered, what, in your opinion, is an acceptable or reasonable period over which to keep a judgment reserved in a very complex matter?
Well, Chief Justice, this was the first matter of such complexity that I was confronted by. I returned to practice having completed that stint. I did my level best to try delivering the judgment as soon as I could. I expected the judgment to have been delivered within 3 months. Circumstances precluded that. I expected then the judgment to have been delivered within 4 months. That would have been 4 to 6 months, I would guess, the reasonable period, Chief Justice.
4 to 6 would have been reasonable.
Yes.
Yes. You see, I'm sitting on this thing because we've had a fair amount of challenges relating to judgments reserved by practitioners who are acting. You know, some take as long as 10 months, 12 months, even 2 years. And when the judge president says, when can I expect a judgment? I remember reading a letter from one advocate who was no longer acting, said, listen, I'm not able to commit myself to any date. I'll deliver it when I deliver it. So that's why I'm seeking to understand whether reserved, when you go back to practice, does it enjoy priority? If it does, how then is it possible for it to be kept reserved for as long as 9 months? So I'm just trying to give you the benefit of the doubt so that we don't draw inferences.
Indeed, Chief
We
Justice.
work on the basis of the reasonable explanation that you provide us with.
Chief Justice, when I returned, the matter was heard in September last year. And when I completed my acting stint at the end of September last year, I came back into practice and was met with a tide of professional commitments that accumulated in my absence. These commitments spewed through into the first term, and although I sought to find time to write the judgment in between.
To find or to make?
Let me correct myself on that score. To make the time, Chief Justice. The delay was entirely circumstantial.
Acting Judge President?
Rugunanan.
Good afternoon, Acting DJP, Judge President.
A comment was made by my colleagues to me with regard to your application and that of others, how that your acting stint has not been sufficient enough for the candidates, not just you, to proceed to this platform for the purposes of an application. What's your comment? That's what my senior judges had to say to me. Would you regard the period within which you have acted to be sufficient for you to be appointed as judge?
Well, I must confess that it's the first time I hear this, but I must say, with all humility, that during the number of acting stints that I performed, I discharged my duties in accordance with the Judicial Oath of Office. Most of my judgments circulated on the SAFLI website have been delivered on time. I've always been accessible to practitioners, and when I was confronted by situations, I conferred with senior judges so as not to venture out of my depth without any consultation. During my acting stints, there's not been, to my knowledge, any complaint about my conduct or the manner in which I've dealt with practitioners, both in chambers and in court. I do believe, and this is entirely a subjective view, that having regard to my career, my practice at the bar, and the occasions that I've acted in Port Elizabeth, Grahamstown, and recently in Bishu and in East London, that this commission may consider that I am appropriately qualified and fit and proper to hold judicial office.
Thank you, President. I have no further questions.
Thank you, AJP. Premium?
I'm fine. Thank you.
That's the list. Dr. JP?
Thank you very much, President. Just two things that I would like to put to you. I'm speaking now as a head of court. The experience shows that with regard to acting positions and reserve judgments, colleagues who reserve judgments for far too long, when they are acting, the moment they are appointed and they are permanent, they become worse. They become worse, and we are stuck with them in the system. Right? I'll give you an opportunity to comment on that. Secondly, it seems to me, I would like you to take us to confidence relating to this matter, the judgment of which was reserved for 9 months. What was so difficult, considering that it was motion proceedings, and you had the benefit of 2 senior counsel appearing before you? What was so difficult about it? Please explain to us. Thank you.
I might have to venture into some detail regarding the facts and the law of the matter, and I'm not quite sure. I'll seek guidance from this commission if I should do so, considering that an application for leave to appeal against that judgment has been launched, which application I will be dealing with on Friday this week. The matter concerned a dispute between 2 landowners in Kenton-on-Sea. And it's been reported on fairly widely in the media in the Eastern Cape. It concerned the demolition of a luxury home, and it also concerned the application of the relevant legislation concerning the implementation of demolitions and safety regulations attendant on the implementation of demolitions. The matter had a complicated history, going back many years, more than 10 years, and in that period, the matter received the attention at some point of the Supreme Court of Appeal. It also received the attention, I believe, of the Constitutional Court, which dismissed an application for leave to appeal, and it came back to the Eastern Cape Division on an altogether different issue, namely the variation of a court order issued by a judge of equal standing, coupled with relief that one of the parties was seeking, that the person who was directed to demolish the dwelling be held in contempt for failure to do so within a specific period of time. That's as far as the facts go. I'm not quite sure if I'm at liberty to expand any further. I have indicated that.
So far, I haven't had anything difficult. Carry on.
Yes, the dispute between the parties was encapsulated in expert reports that have been referred to in the judgment, also in what was called demolition implementation plans and demolition environmental management plans. And the nub of the issue simply is whether, well, the party seeking variation contended that he sought a variation of an order of court on the basis that he was in possession of an administrative resolution taken by a municipality which authorized him not to demolish the premises for safety reasons. The opposing party said, no, you cannot do that. You need to approach this court on the basis that if you are seeking to vary an order of court given by a sitting judge, then you need to approach the matter on the basis that you make out a case on the common law. That was one of the issues. The other issue dealt obviously with the contempt part of the application. To have written the judgment required me to read, as I indicated, the papers were extremely voluminous. I've also had to have regard to the judgments of the court in Grahamstown, the court of first instance, as also the court of the Supreme Court of Appeal.
Sorry, through you, Chief Justice. In the interest of time, I've gone through the judgment. It was 28 pages at the end of the day.
Yes.
Did you have occasion to read the papers? You said it was 700 pages.
Yes.
Did you have occasion to read the papers thoroughly before you went to court, so that at the time when the matter was heard, you were on top of issues and you could ask counsel, you could direct them to address you on specific issues, which you will have read before you went to court?
Yes, I did have opportunity to read the papers, but obviously being confronted by subject matter of the nature, I gave counsel the latitude of making their detailed submissions. I also sought clarity on a number of aspects, in particular, what was the status of I, as a sitting judge, recognizing or giving recognition to the administrative decision taken by the competent authority. So yes, indeed, I did interact with counsel. There was also an application to strike out which preceded the hearing of the main application, and that application was argued at considerable length. I did comment thereon in my judgment.
So just for my own sake, if you were to say 1, 2, 3, what were the very complex issues? Was it the law? Was it the facts? Was it the multiplicity of applications? What were the very complex issues?
Thank you for summarizing it in your question. That's the 1, 2, 3, Chief Justice. I could not put it any better.
Okay. Thank you. Deputy Minister?
Thanks, Chief Justice. Good afternoon.
Good afternoon.
I'm not sure why we had to have the secrecy about the judgment. You wouldn't give us the case a name. It was H versus L. And it's only then looking through the documentations and seeing it referred to in a letter and then finding, as I'm sure JP Hlophe did, finding that we've got the judgment in our file.
My sincere apologies.
Okay. But having said that, I wanted to know, as far as that judgment, did you get permission from the JP to delay the handing down of the judgment?
I did confer with the senior judge at the time I finished my acting stint, and earlier this year I did so as well. It was brought to my attention what the norms and standards required, but as I indicated, I assume responsibility alone, Chief Justice and honorable members of this commission, for the delay in the judgment.
Yes, but so you didn't get the permission of the judge president or acting judge president?
I simply spoke to the senior judge at the time.
Okay. Are you aware of the judge's code of conduct, Article 10, Sub 2? A judge must deliver all reserved judgments before the end of the term in which the hearing of a matter was completed, but may, A is not relevant, B, where a reserved judgment is of a complex nature, I think that's what you're saying this one was, or for any other cogent and sound reason, and with the consent of the head of court, deliver the reserved judgment during the course of the next term. You didn't keep to that, but you didn't with the consent of the head of court.
No,
you didn't abide by this code?
Yes.
Okay, thank you.
Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Counsel.
Good afternoon, Commissioner.
Sorry, I just want just one question for me. If you've attached a judgment, Fatima van Breda versus the state.
Yes.
What struck me is the fact that you signed on behalf of the senior judge.
That's correct. I did so with his express permission.
Is that the practice in the Eastern Cape?
I'm not aware if it was a practice, but I at the time the judgment was written, I was in one center, he was in another. And I did confer with him on this, and he indicated to me expressly that I could sign it on his behalf. I'm not sure whether this is the practice in the Eastern
Well,
Cape.
I've acted in that division. In fact, I've acted throughout the country. I've never come across a situation where a junior judge signs for this senior judge. Thank you, Chief Justice.
Thank you. Now, tell me, Advocate, did you know or did you not know that at the end of 8 months, if you keep a judgment reserved for that long, you must actually be reported to the Judicial Service Commission for disciplinary measures to kick into operation?
In all sincerity, Chief Justice, I was not aware of that.
You are not even aware that it is only with the permission of the head of court that you can be allowed to go beyond that period, which is already too long. You didn't know.
That's correct, Chief Justice.
You didn't familiarize yourself with the environment within which you operate.
To the extent that, yes.
When did you become aware
Chief Justice,
of that reality that nonsense standards, 3 months, it's red lights, finish. 8 months, you must now face the consequences.
Chief Justice, I only became aware of it during the course of this year. I can't say when exactly. It must have been round about July or August.
Yes. All right. Thank you very much. Your excuse, sir.
Thank you, Chief Justice. Thank
Yeah.
you.